Get off this property now. Excuse me? This is my house. I received a call about a suspicious person. You need to leave. I live here. I own this house. The homeowner is listed as Margaret Sullivan. You're trespassing. I am Margaret Sullivan, Federal Judge Margaret Sullivan. This is my property. I don't care who you say you are. You're leaving now or you're under arrest. Officer Derek Hansen had been with the Portland Police Department for 6 years when he walked into a situation that would destroy his career and cost the city $3,800,000. He was 31 years old, experienced enough to know better, but apparently convinced that his assumptions about who belongs in expensive neighborhoods were more reliable than physical evidence. One Saturday afternoon in a quiet residential neighborhood, he received a call about a suspicious person on a porch and confronted Judge Margaret Sullivan, a federal magistrate judge who had lived in that house for 14 years. What Hansen did next, dismissing her identification, ignoring her ownership documents, and threatening to arrest her on her own property, would become proof of how racial bias overrides reason and destroys careers. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. A black woman in her late 50s, Federal Magistrate Judge Margaret Sullivan, was sitting on the front porch of her craftsman-style home in the Eastmoreland neighborhood of Portland, reading case files and enjoying the late afternoon sun. Her judicial identification was inside on her desk, her car keys on the small table beside her wicker chair. No crime, no disturbance, no violation. Just a federal judge reviewing legal documents at her own house on a Saturday afternoon. But Officer Hansen saw her through a filter so distorted by assumptions about who belongs in affluent neighborhoods that he could not process a black woman as the legitimate owner of a 4-bedroom home in one of Portland's most expensive areas. The Eastmoreland neighborhood sits in southeast Portland, bordered by Reed College to the north and the Eastmoreland Golf Course to the south. It is the kind of neighborhood where homes sell for over $1 million, where tree-lined streets are meticulously maintained, and where residents take pride in their historic craftsmen and colonial revival architecture. The area was developed in the 1910 to 1920 era and remains one of Portland's most desirable addresses. Properties here feature large lots, mature landscaping, and the kind of quiet suburban atmosphere that attracts doctors, attorneys, executives, and professionals who value both prestige and privacy. It was 3:15 on a Saturday afternoon in late September. The temperature was a comfortable 72 degrees. Sunlight filtered through the large maple trees that lined the street. A few neighbors were out working in their yards. Children rode bicycles on the sidewalk. The kind of peaceful Saturday afternoon where nothing dramatic typically happens. Federal Magistrate Judge Margaret Sullivan had been on the bench for 12 years. 12 years presiding over criminal and civil proceedings, making rulings that affected lives and shaped legal precedent, and maintaining the impartiality and composure required of federal judiciary. She had spent 8 years before that as an assistant United States attorney, prosecuting federal crimes that ranged from drug trafficking to white-collar fraud to civil rights violations. 4 years before that as a public defender, ensuring that indigent defendants received competent representation. Her career in law spanned 24 years of service to the justice system at every level. Judge Sullivan had graduated from Howard University School of Law, where she had served as executive editor of the Howard Law Journal and graduated magna cum laude. She had clerked for Judge Patricia Wald on the United States Court of Appeals for the District of Columbia Circuit, one of the most prestigious clerkships available to young attorneys. She had argued cases before circuit courts, tried complex federal cases, and built a reputation for thorough legal analysis and fair rulings. When President Barack Obama nominated her to the federal magistrate judgeship for the District of Oregon, she was confirmed unanimously by the Senate Judiciary Committee. Her colleagues on the bench called her meticulous and fair. Attorneys who appeared before her called her demanding but just. Legal scholars cited her well-reasoned opinions in academic journals. At 57 years old, Margaret Sullivan was exactly where she had worked to be, respected as one of the most capable jurists in the District of Oregon, trusted with complex cases that required both legal expertise and judicial temperament. She had sacrificed personal relationships and countless weekends to build her career, studying late into the night, taking on difficult cases, and maintaining the highest ethical standards. She had purchased her home in Eastmoreland 14 years ago, a beautifully maintained 1920 Craftsman with original hardwood floors, built-in bookcases, and a wraparound porch where she often sat to read legal briefs and enjoy the neighborhood she had worked so hard to afford. That Saturday afternoon, Judge Sullivan was off the bench but working through case files for upcoming hearings scheduled for Monday morning. She had settled into her favorite wicker chair on the front porch at 2:30, bringing out a stack of criminal case files, a thermos of tea, and her reading glasses. She wore casual weekend clothes, jeans, and a Howard Law sweatshirt. Comfortable clothing appropriate for a Saturday at home. Her judicial identification was inside on her home office desk. Her car, a silver Lexus sedan, sat in the driveway with judicial parking credentials visible on the dashboard. She looked like what she was, a professional woman working at home on a weekend. She had done nothing to attract attention. She had waved to neighbors who walked past. She had smiled at children riding bicycles. She had been sitting on her own porch, on her own property, bothering no one. But to someone in that neighborhood, Judge Margaret Sullivan's presence on that porch was suspicious. And that person had decided to call the police. Sandra Whitmore was 73 years old. She had lived in Eastmoreland for 41 years, raised 3 children in her colonial-style home 2 blocks from Judge Sullivan's house, and considered herself the unofficial guardian of neighborhood standards. She was retired from a career in real estate, active in the neighborhood association, and deeply concerned about maintaining what she called the character of Eastmoreland. She wanted the neighborhood to remain the way it had always been, quiet, safe, and occupied by the right kind of people. That Saturday afternoon, Whitmore was driving home from the grocery store when she passed Judge Sullivan's house. She saw a black woman sitting on the porch, and something about the scene struck her as wrong. She had seen the house change ownership years ago, but she had never seen the current owner. In her mind, the pieces did not fit. This was Eastmoreland. Homes here cost over $1 million. Black people did not typically own homes in this neighborhood unless something unusual was going on. The woman must be a squatter, or perhaps a caretaker who was taking liberties, sitting on the front porch as if she owned the place. Whitmore drove past slowly, watching. The woman appeared to be reading documents, comfortable and settled in, clearly not planning to leave anytime soon. In Whitmore's mind, this required investigation. She drove around the block, past the house again to confirm what she had seen, and then pulled over 3 houses down. She pulled out her phone and called the police non-emergency line. The call was logged at 3:07. A woman reported a suspicious person sitting on a porch at 4217 Southeast Woodstock Boulevard. The dispatcher asked standard questions about whether the person was engaged in criminal activity or causing a disturbance. Whitmore could not identify any actual crime, but insisted that something seemed wrong, that the person did not appear to belong there, that perhaps the homeowner was being taken advantage of by staff or service workers who were not authorized to use the front porch. The dispatcher logged the call as a suspicious person report. A patrol unit was assigned. Officer Derek Hansen responded. Do you think neighbors should face consequences for calling police based on assumptions about who belongs in their neighborhood? Drop your answer below. Derek Hansen had been with the Portland Police Department for 6 years. In that time, he had compiled a record that should have raised immediate concerns at every supervisory level. 9 complaints, 9 separate incidents over 6 years, where citizens had accused him of racial profiling, excessive force, or discriminatory treatment. 4 of those complaints had been sustained after investigation, resulting in written reprimands and mandatory bias training sessions. The other 5 had been closed as not sustained or unfounded, despite witness testimony and documented inconsistencies in Hansen's reports that suggested the complaints had merit but lacked definitive proof. Hansen had a clear pattern. He responded to calls in affluent neighborhoods with an assumption that people of color were out of place unless they could prove otherwise. He demanded identification from black residents in situations where white residents would never be questioned. He interpreted normal behavior as suspicious when the person engaged in that behavior was not white. 2 years earlier, Hansen had detained a black man for 20 minutes while the man was jogging through Eastmoreland, demanding identification and questioning why he was running in that neighborhood, despite the fact that dozens of white joggers used those same streets every day without being stopped. 1 year earlier, Hansen had questioned a Hispanic landscaping crew about their immigration status and work permits while they were maintaining a client's yard, despite having no legal authority to enforce immigration law and no reason to believe any crime was occurring. 6 months earlier, Hansen had pulled over an Asian family in a newer BMW, claiming their temporary license plates looked suspicious, then spent 15 minutes questioning where they worked and how they could afford such an expensive vehicle. The pattern was documented: 9 complaints with detailed incident reports, 4 sustained findings with explicit conclusions that Hansen had engaged in biased policing, training completion certificates showing he had attended bias awareness courses, de-escalation training, and community policing seminars, supervisor evaluations noting that Hansen demonstrated strong enforcement activity but needed improvement in community relations and cultural sensitivity. Yet somehow Hansen remained on patrol, his supervisors treating each incident as an isolated mistake rather than recognizing the pattern that was clearly visible to anyone reviewing his file. When Hansen received the call about a suspicious person on a porch in Eastmoreland, his mind immediately constructed a narrative. Expensive neighborhood, suspicious person reported, probably does not belong there, likely trespassing or up to something. He arrived at 4217 Southeast Woodstock Boulevard at 3:14, parking his patrol car directly in front of the house. He got out, adjusted his duty belt, and walked up the front path toward the porch where Judge Sullivan sat reading. Judge Sullivan was reviewing a sentencing memorandum when she heard footsteps on her front walk. She looked up and saw a police officer approaching her porch, his posture suggesting authority and suspicion rather than a routine welfare check. She immediately felt the familiar tension that many Black professionals know well, the awareness that even in your own space, your presence can be questioned. Get off this property now. Judge Sullivan blinked, momentarily confused by the aggressive command. Excuse me? This is my house. Hansen stopped at the base of the porch steps, arms crossed. I received a call about a suspicious person at this address. You need to leave the property. Judge Sullivan felt her stomach tighten, recognizing exactly what was happening. I live here. I own this house. I'm sitting on my own porch. Hansen's expression hardened. The homeowner is listed as Margaret Sullivan. You're not Margaret Sullivan. Judge Sullivan stood slowly, setting her case files on the small table beside her chair. I am Margaret Sullivan, Federal Magistrate Judge Margaret Sullivan, and you are on my property without cause. Hansen's jaw clenched. I don't care who you say you are. I'm responding to a complaint, and I need to see identification, proving you have authorization to be here. This is where bias becomes impenetrable. Officer Hansen had responded to a call about a suspicious person on a porch. When he arrived, he saw a Black woman on a porch in an expensive neighborhood. In his mind, that confirmed the complaint. Every piece of evidence after that, her statement of ownership, her calm professional demeanor, her knowledge of the homeowner's name, was filtered through his initial assumption. He was not looking at a homeowner on her own property. He was looking at someone who did not belong and was making excuses to avoid consequences. Judge Sullivan kept her voice measured and clear. Officer, I am not required to show you identification while sitting on my own property. I have committed no crime. I have given you no reasonable suspicion of criminal activity. You have no legal basis to demand identification from me. Hansen took a step closer to the porch. Ma'am, I'm not going to ask again. Show me ID or leave the property. I am not leaving my own property, and I am not required to show identification to satisfy your curiosity or respond to a neighbor's racist assumption about who lives in this neighborhood. Hansen's hand moved to his radio. You're refusing a lawful order from a police officer. That's obstruction. It is not a lawful order. You have no probable cause, no reasonable suspicion, and no authority to remove me from my own property. I am Federal Magistrate Judge Margaret Sullivan. I have presided over the United States District Court for the District of Oregon for 12 years. I know exactly what the law requires, and what you are doing right now violates my Fourth Amendment rights against unreasonable seizure. The front door of the house opened. Judge Sullivan's husband, David Sullivan, a white man in his early 60s and a retired attorney, stepped onto the porch. He had been inside working in his home office when he heard the confrontation. Officer, what's going on here? Hansen turned his attention to David. Sir, are you the homeowner? We are both homeowners. This is my wife, Judge Margaret Sullivan. We've lived here for 14 years. Hansen's expression showed confusion for the first time. You're married? David stepped beside his wife, his voice calm but firm. Yes, we're married. This is our house. My wife was sitting on our porch reading legal documents when you arrived and started making demands. What complaint did you receive that justified coming onto our property and ordering my wife to leave? A neighbor called about a suspicious person. David looked at his wife, then back at Hansen. A suspicious person. My wife. A federal judge. Sitting on her own porch, reading, on a Saturday afternoon. And someone called that in as suspicious. Hansen shifted his weight, his confidence beginning to erode. I'm just responding to the call, sir. Judge Sullivan's voice remained controlled, but carried an edge of authority that came from years on the bench. Officer, what is your name and badge number? Hansen, badge 3472. Officer Hansen, I am going inside to retrieve my judicial identification. I am informing you of my actions, so you do not interpret my movement as threatening. I will return with documentation proving I am exactly who I say I am. Documentation you had no legal right to demand, but which I am providing to document this encounter. Do you understand? Hansen nodded, his earlier aggression replaced by growing uncertainty. Judge Sullivan walked into her house, her husband remaining on the porch. She returned 2 minutes later carrying her judicial identification in its official case, along with her driver's license, the deed to the property, and a recent utility bill with her name and address clearly printed. She held them out for Hansen to examine. Hansen took the documents with hands that were no longer quite steady. The judicial identification was unmistakable. United States District Court, District of Oregon, Magistrate Judge Margaret Sullivan, with her photograph, signature, and official seal. The driver's license matched the judicial identification. The property deed showed Margaret Sullivan and David Sullivan as owners of 4217 Southeast Woodstock Boulevard, recorded with Multnomah County. The utility bill was addressed to Judge Margaret Sullivan at the same address. Hansen stared at the documents for a long moment. His face had gone pale. Ma'am, I apologize. I was just responding to a call. Judge Sullivan's voice remained calm but carried unmistakable steel. You were not just responding to a call. You demanded that I leave my own property. You threatened to arrest me for sitting on my own porch. You refused to accept my statement that I own this house. You dismissed my identification as a federal judge. You did all of this because someone called to report a black woman on a porch in an expensive neighborhood, and you assumed that black woman must be trespassing. Officer, I had to verify the situation. You had to verify nothing. You had no probable cause. You had no reasonable suspicion of criminal activity. A person sitting on a porch reading documents is not suspicious behavior. It is normal Saturday afternoon behavior that happens on hundreds of porches in this city right now. But when you saw a black woman on this porch, you assumed she was committing a crime. By this point, several neighbors had noticed the patrol car and come outside. 2 women stood on the sidewalk watching. A man across the street stood in his driveway. Another neighbor was recording the interaction on her phone. David Sullivan addressed Hansen directly. Officer, my wife and I have lived in this neighborhood for 14 years. We have never had any problems until today. The problem today is not that my wife was on our porch. The problem is that someone saw a black woman and decided that was suspicious enough to call the police. And the problem is that you arrived and immediately assumed the caller was right without conducting any actual investigation or applying any common sense. Should officers be required to verify property ownership before ordering people off their own property? Let me know what you think. Hansen's supervisor arrived 18 minutes later. Sergeant Linda Morrison was a 19-year veteran who had worked in Eastmoreland before and understood the dynamics of policing affluent neighborhoods where racial bias complaints were not uncommon. She had been listening to the radio traffic and recognized immediately that the situation was problematic. When she arrived, she found Hansen standing awkwardly at the base of the porch while Judge Sullivan and her husband stood at the railing with several neighbors watching from the street. Morrison approached and immediately addressed Judge Sullivan. Your Honor, I'm Sergeant Morrison. Can you tell me what happened here? Judge Sullivan recounted the incident methodically, speaking as she would from the bench, presenting facts in chronological order without emotional embellishment. Morrison listened, her expression growing increasingly concerned. She asked to see Judge Sullivan's identification, not to verify it, but to document what Hansen should have accepted immediately. She asked Hansen for his version, which largely confirmed what Judge Sullivan had described. Though Hansen framed his actions as reasonable response to a call, Morrison turned to Hansen with barely concealed anger. You ordered a federal judge off her own property based on a suspicious person call with no description of criminal activity? I was responding to the complaint, Sergeant. You respond to complaints by investigating, not by making immediate assumptions. Did you ask Judge Sullivan if she lived there before ordering her off the property? She said she did, but I needed to verify. How did you attempt to verify? Did you ask to see identification before threatening arrest? Did you ask if there was anyone inside who could confirm her residence? Did you look at the mailbox with her name on it? Did you notice the car in the driveway with judicial parking credentials? Hansen had no answer. Morrison turned back to Judge Sullivan. Your Honor, on behalf of the Portland Police Bureau, I sincerely apologize. This should never have happened. Officer Hansen had no legal basis to order you off your property or to demand identification without reasonable suspicion of criminal activity. This was a violation of your rights, and there will be accountability. Judge Sullivan nodded. Sergeant, I appreciate your acknowledgement. However, I need you to understand that this is not an isolated incident. This is part of a pattern. I am a federal judge, and I was treated this way on my own property. I have resources, credentials, and knowledge of the law to fight back. But this happens to Black people every day who do not have those advantages. This happens to people who get arrested, charged, or worse, because an officer made assumptions based on race. Officer Hansen needs to be removed from duty, and your department needs to address the systemic issues that made this possible. Morrison nodded. I understand, Your Honor. Officer Hansen will be placed on administrative leave immediately pending investigation. That is not sufficient. I will be filing a formal complaint with your Internal Affairs Division. I will be contacting the Department of Justice to request an investigation into Officer Hansen's complaint history and the Portland Police Bureau's response to those complaints. And I will be consulting with attorneys about civil litigation. This needs to be documented, investigated, and addressed at every level. Morrison turned to Hansen. Badge and radio. Administrative leave effective immediately. Hansen removed his badge and radio with shaking hands and gave them to Morrison. For the first time, he appeared to fully understand the magnitude of his mistake. He walked back to his patrol car without another word. Morrison called for another unit to drive Hansen back to the precinct. Should officers face automatic termination after violating the constitutional rights of judges in their own homes? Drop your answer. Within 6 hours, the story had spread through Portland's legal community. Attorneys who practice in federal court contacted Judge Sullivan to express outrage and support. Other judges, both federal and state, reached out privately. The story reached local media by that evening. A neighbor who had recorded part of the interaction provided the video to news outlets. Federal judge ordered off her own porch by Portland officer. Magistrate judge confronted on her property after neighbor reports suspicious person. Black federal judge told to leave her own home by officer responding to racial bias call. The outrage was immediate and widespread. The Federal Bar Association issued a statement condemning the incident and calling for immediate reforms. The Oregon chapter of the NAACP demanded accountability and systemic changes. Civil rights organizations across the state pointed to the incident as proof that even judges are not protected from racial profiling. Officer Derek Hansen's career unraveled within days. The Portland Police Bureau placed him on administrative leave and opened an internal investigation. Media outlets requested his personnel file under public records law. His complaint history became public. 9 complaints over 6 years, 4 sustained, all involving allegations of racial bias or discriminatory treatment. Yet he had remained on patrol with nothing more than training and written reprimands. Sandra Whitmore, the neighbor who had made the call, was identified through investigative reporting. She initially defended her decision, claiming she was just trying to protect the neighborhood. When reporters pressed her on what specifically was suspicious about a woman sitting on a porch reading, she could not articulate an answer beyond a vague sense that something seemed wrong. She faced intense public criticism. Neighbors who had considered her a community pillar now saw her differently. Her name became associated with racial profiling and bias. Judge Margaret Sullivan retained civil rights attorneys within a week. The lawsuit, filed 3 weeks after the incident, named Officer Derek Hansen, Sergeant Linda Morrison for supervisory failure given Hansen's documented complaint history, Sandra Whitmore personally for initiating the discriminatory call, and the city of Portland. The claims were comprehensive and damning. Violation of Fourth Amendment rights against unreasonable seizure, violation of 14th Amendment rights to equal protection under the law, racial profiling and discrimination, intentional infliction of emotional distress, violation of Oregon state laws protecting citizens from discriminatory policing, failure to train and supervise an officer with a documented pattern of racially biased behavior, failure to implement adequate policies to prevent racial profiling in response to biased civilian complaints. The complaint included Hansen's complete personnel file, 9 complaints over 6 years, 4 sustained findings explicitly concluding that Hansen had engaged in discriminatory policing, training certificates showing he had completed bias awareness courses that clearly had no effect on his behavior, supervisor evaluations documenting concerns about his community relations but recommending no discipline beyond additional training, a clear pattern that the city had documented but failed to address meaningfully. The city's attorneys reviewed the evidence over the following months. Video recording from a neighbor showing Hansen ordering Judge Sullivan off her property. Judge Sullivan's own testimony, which would carry enormous weight given her position and credibility. David Sullivan's corroborating testimony. Multiple neighbors who witnessed the confrontation. Hansen's own admission that he had ordered her off the property before investigating. Documentation showing no crime had occurred and no reasonable suspicion existed. Hansen's complaint history showing a clear pattern of exactly this type of behavior. Legal precedent firmly establishing that officers cannot order people off their own property without cause. The city's legal assessment was unequivocal. The case was completely indefensible. Any jury would side with a federal judge who was ordered off her own porch for sitting there while black. The city settled 14 months later, paying $3,800,000 to Judge Margaret Sullivan. Sandra Whitmore's homeowner's insurance contributed an additional $400,000 in a separate settlement. Officer Derek Hansen was terminated 11 weeks after the incident. The termination letter was final and comprehensive. Officer Hansen violated the constitutional rights of a citizen by ordering her to leave her own property without probable cause or reasonable suspicion of criminal activity. He engaged in racial profiling by assuming criminal behavior based solely on the presence of a black woman in an affluent neighborhood. He failed to conduct any meaningful investigation before making threats of arrest. He ignored clear evidence that contradicted his assumptions. Despite 9 prior complaints and 4 sustained findings involving discriminatory policing, Officer Hansen continued to demonstrate racially biased law enforcement practices. His employment with the Portland Police Bureau is terminated immediately. Hansen's name was entered into the National Decertification Index. His law enforcement career ended at 31 years old. He released no public statement and declined all media requests for interviews. The Portland Police Bureau faced intense scrutiny from both the community and oversight bodies. The Department of Justice opened an investigation into the Bureau's handling of complaints against Hansen and its broader practices regarding racial profiling. Internal Affairs conducted a comprehensive review that exposed systemic failures. The review found that 9 complaints over 6 years with 4 sustained findings had resulted in no meaningful discipline. Training requirements had been completed but never assessed for effectiveness. Supervisors had documented concerns but taken no action to remove Hansen from positions where he could continue the same behavior. No mechanism existed to identify officers with patterns of discriminatory complaints and intervene before those patterns resulted in civil rights violations. No accountability structure existed to hold supervisors responsible for failing to address documented patterns in officers under their command. Reform measures were announced within 6 months. Immediate administrative leave for any officer with 3 or more sustained complaints related to bias or discrimination. Mandatory quarterly pattern analysis of all officer complaints with automatic supervisory review when patterns emerge. Independent civilian oversight board with authority to investigate complaints and recommend discipline. Required supervisor accountability when officers under their command accumulate multiple bias-related complaints without intervention. Revised training requirements with measurable behavioral outcomes and regular assessment. Automatic notification to the Department of Justice when federal officials are subject to law enforcement action. Judge Margaret Sullivan testified at City Council hearings examining police practices and accountability. Her testimony was measured, factual, and devastating in its clarity. I am a federal magistrate judge with 12 years on the bench and 24 years practicing law. I have presided over criminal cases, civil rights cases, and countless proceedings involving law enforcement. I understand the challenges officers face and the split-second decisions they must make in genuinely dangerous situations. She paused to let that acknowledgement register. What happened to me was not a split-second decision in a dangerous situation. I was sitting on my porch reading legal documents on a Saturday afternoon. A neighbor saw a black woman and called the police. Officer Hansen arrived and immediately ordered me off my property without asking a single investigative question, without observing any suspicious behavior, without any reasonable suspicion of criminal activity. When I told him I owned the house, he did not believe me. When I identified myself as a federal judge, he dismissed that information. He was prepared to arrest me on my own property for the crime of sitting on my porch while black. Another pause. Officer Hansen had 9 complaints in 6 years. 9. 4 were sustained with explicit findings that he engaged in racial profiling. 4 times your department concluded that this officer treated people differently based on race. Yet he remained on patrol with nothing more than training that clearly did not change his behavior. That is a failure of supervision, a failure of accountability, and a failure to protect the community from an officer who repeatedly violated civil rights. Her voice strengthened. I am a federal judge. I have resources to fight back. I have attorneys, credibility, and knowledge of the law. I filed a lawsuit and your city is paying $3,800,000 because you failed to remove an officer who demonstrated again and again that he could not police without racial bias. But what about everyone else? What about the black residents who get ordered off their own porches but cannot afford lawyers? What about the people who get arrested, charged, or hurt because an officer made assumptions based on skin color? My case is public because I am a judge. How many cases are not public because the victims do not have my position? She looked directly at the council members and the chief of police. If this can happen to a federal magistrate judge on her own property in broad daylight with witnesses present, what happens every day to people without my credentials, without my resources, without my ability to demand accountability? That is the question your department must answer. That is the systemic problem you must fix. The hearing room remained silent as her words settled over everyone present. Should racial profiling complaints trigger automatic federal investigation when patterns emerge? Drop your answer below. This was not just about one officer ordering one judge off one porch. This was about a system that documented Derek Hansen's pattern of racially biased policing through 9 complaints and 4 sustained findings, but responded with nothing more than training sessions and written reprimands that changed nothing. This was about supervisors who noted concerns and evaluations but failed to connect those concerns to the complaint pattern building in his file. This was about a department that treated each incident in isolation rather than recognizing the clear trajectory of an officer who should have been removed from patrol years before he confronted a federal judge. Officer Hansen's assumptions were so ingrained, so automatic, that even when faced with a federal judge on her own property, he could not override his bias. A black woman on a porch in an expensive neighborhood had to be trespassing because black women do not own houses in Eastmoreland. When she said she owned the house, she had to be lying. When she identified herself as a federal judge, that had to be an excuse to avoid consequences. His mind had already decided the outcome before he examined any evidence. This is how systemic racism operates in everyday interactions. It is not always violent. It is not always dramatic. Sometimes it is quiet and ordinary, built on assumptions that seem reasonable until examined. A neighbor sees a black woman and calls the police. An officer responds and immediately assumes the black woman is the problem. The system validates those assumptions until the victim has enough power to fight back. Sandra Whitmore saw a black woman and decided that was suspicious. Officer Hansen arrived and agreed that was suspicious. Neither of them considered that a black woman might legitimately own a house worth over $1 million in Eastmoreland. Neither of them paused to question their assumptions. Their bias was so normalized that it felt like common sense, like protecting the neighborhood, like doing their duty. Derek Hansen's career is over. That is justice. The city paid $3,800,000. That is accountability. Sandra Whitmore faced public condemnation and financial consequences. That is social accountability. The Portland Police Bureau implemented new policies and oversight. That is reform. But money and termination do not undo the trauma of being ordered off your own property by an armed officer. Policy changes do not erase the message that even a federal judgeship is not enough to protect you from being treated like a criminal in your own home. Reform measures do not undo the years of complaints that were documented but ignored, while Derek Hansen continued to police with racial bias. The real question is, what changes now beyond one termination and one settlement? Do police departments finally remove officers after 3 sustained complaints involving racial bias instead of waiting for the 9th complaint to target someone with federal authority? Do supervisors finally face accountability when officers under their command accumulate documented patterns without intervention? Do we finally acknowledge that sitting on your own porch should not require credentials and lawyers to defend? Because if we do not fix the systems that kept Hansen on patrol for 6 years despite 9 complaints, if we do not address the culture that taught Sandra Whitmore to see black neighbors as suspicious, if we do not change the assumptions that equate blackness with criminal behavior, then we are just waiting for the next Derek Hansen, the next Sandra Whitmore, the next victim, and the next lawsuit. Comment if you believe this should be law. Officers with 3 or more sustained complaints involving racial bias face automatic removal from patrol duty. Civilians who call police based on racial bias rather than actual criminal behavior face financial penalties and mandatory education. Supervisors face disciplinary action when officers under their command accumulate complaint patterns without intervention. And if you think these stories need to be told, if you believe accountability starts with awareness and change starts with sustained public pressure, then hit that subscribe button. We are not stopping. We are going to keep exposing these patterns of bias and abuse. We are going to keep demanding better from the institutions that are supposed to serve all communities equally. We are going to keep fighting for the federal judges, the homeowners, the ordinary people who deserve to exist on their own property without being criminalized for their skin color. This is not just about one officer who could not see past his racial bias. This is not just about one neighbor who called the police on a black woman for sitting on a porch. This is not just about one judge who had the credentials and resources to fight back. It is about all of us and the world we are willing to accept, the assumptions we are willing to challenge, and the systems we are willing to change. Because until we do that difficult work of confronting bias wherever it appears and holding people accountable when they act on it, the next confrontation is already waiting to happen.